We often include the arbitration clause in the agreement thinking it will avoid the struggles of the civil court as the matter will be referred to the arbitration and the same will be decided very easily with less litigation costs and in a timely manner. But is it always true? The answer is no. What if I say even if you have the arbitration clause or the arbitration agreement, still the other party can approach the civil court and civil court will retain its jurisdiction and will not refer the same to the arbitration even after having your application under section 8 of the Arbitration and Conciliation Act. Now this is an exception rule which could only be understood after the general rule. So let us see the relevant provision of law, that is the section 8 of the Arbitration and Conciliation Act, which says that if a suit has been brought to the civil court with a matter involving the issue already covered by the arbitration agreement, in that case the civil court must refer the same to the arbitration and the civil court must do it regardless of any previous judgments of any court, be it even Supreme Court. And this principle, this law is supported by a Supreme Court ruling also in the case of P. Anand Ganpati Raju versus PVG Raju, which is a ruling of year 2000, which states that if there is any agreement, arbitration agreement between the parties, and either of the party has applied to the court under section 8 for referring the matter to the arbitration, in that case the civil court is under obligation to refer the matter to the arbitration. So it is a duty of the court as per the Supreme Court. So now this section 8 and the Supreme Court ruling gives us a clear indication that the matter will always be referred to the arbitration under the above circumstance. So how am I saying that the other party can easily approach the civil court and civil court will retain its jurisdiction and will not refer the matter to the arbitration? So now let us see the exception rule. So Supreme Court in its 2003 ruling, Sukanya Holding Private Limited versus Jayesh Pandya, held that there can be two circumstances in which even after having the arbitration clause, it will not compel the civil court to refer the matter to the arbitration. Now the first circumstances is mixed subject matter, that is, if the dispute involves the issues which are beyond the control of the arbitration, beyond the scope of the arbitration, in that case the matter will be decided by the civil court. For example, if the arbitration agreement is between the between the partners of a firm and the partnership firm has transactions with some external parties also. So if there is any dispute between the partners because of the transactions done by between the external parties and the firm, in that case, because the external parties are not bound, therefore the issues between the partnership firm and the external parties will not be taken up by the arbitration, and the whole case will be decided by the civil court, because if this dispute will be bifurcated and partly will be given to the arbitration and partly to the civil court, in this case it will lead to multiplicity of proceedings, and the whole purpose of this arbitration of speedy disposal of the disputes and reduction in the cost of litigation will get infructuous. The other circumstances is that if the dispute involves the parties which are not bound by the arbitration agreement. For example, there is an arbitration agreement between two partners of a firm and one of the partner fraudulently sells a common property of the firm to some other person. Now, the civil suit will also include the purchaser of that property which the other partner fraudulently sold, and also the mediator between the purchase and sale of the property. Now the purchaser and the mediator are not bound by the arbitration agreement because they are not the signatories of the agreement. Therefore, this whole issue will be decided by the civil court itself. Now there is another Rajasthan High Court ruling also which will give us a hint that what not to do before the civil court while invoking the powers under section 8 of Arbitration and Conciliation Act. So Rajasthan High Court in its ruling Mahesh Kumar versus RSRTC, which is a ruling of 2006, denied to transfer the matter to the arbitration despite there was an arbitration agreement. This is because the defendant in this matter did not made an application under section 8 of Arbitration and Conciliation Act and further did not show the arbitration agreement to the court. The defendant here only took a plea in his written statement that there is an arbitration agreement, so the matter should be referred to the arbitration and it should not be adjudicated by the civil court. So because section 8 of Arbitration and Conciliation Act explicitly states that there should be an application made under the section 8 and it should be accompanied by an original copy of the arbitration agreement, so it must be followed. Mere having a plea in the written statement can lead to retention of the civil court's jurisdiction. So long story short, even if the civil courts are obligated to transfer the matters to the arbitration under section 8 of the Arbitration and Conciliation Act, still there are exceptions to this rule. And the exception can arise when the dispute involves non-signatories or issues are outside the scope of the arbitration agreement, or there is any procedural lapse, that is there is no application made under Section 8 of the Arbitration and Conciliation Act, or there is no accompanying arbitration agreement also. So it is crucial to draft the arbitration clause very carefully and to follow the required procedure to invoke the same. Consulting an advocate is essential to avoid such complications. So if you found this explanation to be helpful, you can watch this video also by clicking here, in which I have told, even after having an inordinate delay of many years, still how can you condone that delay by the court legally. We'll meet you in the next video. Thank you very much.